The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barkat, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn, joined today by the man of the moment, Jacob Lawrence, fresh off his big victory last week at a jury trial. How you doing, Jacob?
Great, Matt. Thanks for having me again.
It's a pleasure as always. Jacob, today we're actually going to be talking about kind of the elephant in the room. We're asking people to take another look at what it is you and I do for a living. And how we do it, and asking them really to learn about the process, because there are a lot of people that think that a lot of lawsuits are frivolous. Last Monday in court, you had 72 people, potential jurors, and the first question you asked is, who thinks there are too many lawsuits that have been filed? How many paddles did you get for that one, Jacob?
At least 40 paddles, I'd say, at 70. You know, it's a very common held belief.
It is. It's a popular perception. Mm-hmm. But that's the perception that we're gonna try to change. It's no longer the case that somebody can get in a car accident and just sort of shake down the insurance company for money. It's really just not practical.
Yeah, no doubt. I mean, the insurance company, is taking steps immediately after that incident, and
right.
and that's what you got to be prepared for. You got to start right at the beginning.
Right. The insurance company, they know exactly what they're doing. Right after a car accident, they're calling you up. We've talked about it before. They're trying to get a statement from you. They're trying to, get you on the record saying that you're okay, saying that you don't really have any injuries. Even a day or two after the accident, before you really have had time to even get over the initial shock of it. And so. We ask people always call us early in the process because, you got to start working these claims almost immediately.
No doubt.
Yeah. But the one thing we don't want in our office are frivolous lawsuits. I tell my clients all the time, go out and get better, right? I can't get you enough money to compensate you for feeling miserable for the rest of your life. People who come to our office are actually injured. And that's who we're interested in representing. That's who we're interested in fighting for. Because we're going to have to spend a lot of money on your case when you come into our office.
No doubt.
Tell them last week we were in trial. How many experts do you think did you hire for that case?
We used 2 in the trial last week. One was an engineer, and then the second was a doctor.
Right.
And of course, both had sort of different costs associated with their role in the case. Of course, one of the main ones is the engineer needs to do a scene inspection of where the incident takes place, and that's a long process, an expensive process, and a lot goes into that.
Right. So where was he from?
He was from Indianapolis.
Right. So he drives all the way over here once to look at the scene, to investigate it, take measurements, do whatever it is he needs to do as an engineer, and then he comes over again for trial.
Correct.
Yeah.
Exactly.
I don't know. What were your costs at the end of the day on that case? Do you have an estimate?
We had close to $50,000 invested in that case.
Mm-hmm. And if we had lost that case, do we get that money back?
No. Yeah. Just eat that expense.
We write it off. So I mean, we don't take a case unless we believe that, first of all, we can win it, and second of all, we can get those costs back out of it and make it worth our time as a business to file it. $50,000 is not unusual for us in a personal injury case. Our record is well over $250,000 that we spent just to get a case in front of a jury. Thankfully, we won that case, but had we not, that's something we would never have gotten back.
Oh no, and as the example of last week, that was a 2-expert case. I mean, right. in a 2-day trial, when you've got a trial that's going almost a month long or multiple weeks, I mean, we're talking about a handful or more experts. I mean,
right.
Adds up quickly. Yeah,
and in your case, the defense actually didn't hire any experts. Had they done so, you'd have had to take their depositions. That's another $5,000 to $10,000. You're right. That case was a day and a half. I mean, it was relatively short, relatively straightforward, and yet it cost us close to $50,000 just to tell that story. Yeah. So, and that's not, what we spend is certainly a large part of it, but another part of it, the client has to be willing to go out and engage in the treatment that they need in order to get better. That's a process that these people have to disrupt their lives. They have to spend time away from work, away from their family, going to doctor visits, getting the treatment that they need, engaging in therapy. By the time usually if a case walks into our office, it's probably about 3 years before we can get that case ready for trial. People don't live alive for 3 years, right? I mean, that is really hard to do. If they come into our office and they're actually injured, they want to get better, and they're going to work at getting better until they either, get to the point where they've hit a plateau, or they actually do get better. And that's, the perception that people are faking this for 3 years. When we spend so much of our time on social media and so much of our time being videotaped, and defendants even they'll actually surveil you. They'll actually hire a private investigator to come and follow you around. The notion that you can fake that for 3 years, to me, it just doesn't make sense.
Oh, not at all. No, it'll be found out before then. And again, that's the importance of us doing the investigation on the front end and weeding out or picking the cases that we know are the right ones.
That's right. Yeah, we get a pretty good feel for it. I mean, after a while, you've been doing this how long now?
In my 5th year now.
Yeah, I mean, you kind of get a feel meeting with these folks of, who out there is being sincere, who out there, doesn't really know what they're doing. I mean, certainly I've had some people come into our office that we wind up, saying no to.
Oh, yeah. We do it all the time.
Yeah. At what percentage of people you talk to, do you wind up not taking their case?
Wow, that's a great question. I'd probably say it's a quarter of the people that come in.
Yeah.
Maybe 25% that we don't take because of that. Because of it could be for any reason. It could be a liability issue that we don't feel good about. Whether they were at fault in the incident itself, or it could be a medical causation issue, whether they had another traumatic event or a pre-existing condition, something like that.
Sure.
People think, oh, they had a bad back before, they got in a car wreck, and now they're bringing a frivolous lawsuit. As we're saying, it just doesn't work that way.
No, I tell people all the time if they, they maybe come in maybe 3 months after an accident and they said, yeah, my neck hurt, and I said, what'd you do about that? Well, I went and saw my doctor, and he prescribed some physical therapy. I did the physical therapy, and now I'm okay. I'll say, well, how much do you have in medical bills? And they'll say, oh, about $2,000 or $3,000. I said, the insurance company's going to offer you 5 or 6, and I really can't change that. That's really the value of that case. Let's call them right now, and sometimes we'll call the adjuster right there from my office. Hey, I'm about to sign this guy up and start fighting, trying to get $10,000, but if you'll give him 6 right now, he'll go away, right? And he usually gets that, and we don't take a fee for that. We don't, we don't charge for that. That's really, it's not worth our time to prosecute a case that's worth less than $5,000, $10,000. We're going to be working on much larger cases, so. But yeah, so I mean, the notion, if you do get hurt, you do want to come see us. But if you get better within a short period of time after an accident, there's just no point in filing a lawsuit.
You don't want $1 million lawsuit.
You don't. No, we've seen what that looks like.
Yeah.
That's a debilitating injury that is everything you enjoy doing in your life right now. You're not able to do it anymore, or when you do it, you're in excruciating pain. You're running at about 25%. I probably say no to 75% of the cases that come across my desk, but that's because I seem to be the person in our office who looks at the most medical malpractice claims, and that's an area where I won't say that there are never any medical malpractice claims that are frivolous, but it is really hard to file one of those if it is not a straightforward case. So when
why is that? What's the difference between a med mal and just a personal injury case of a different type?
Yeah, so if a medical malpractice claim comes into our office, the first question we have to ask is, did the doctor who treated this patient violate what's known as the standard of care? And that's a question that I really can't answer, right? I'm not a doctor. And before I can even file that lawsuit, I have to get a report from a practicing physician who will tell us, okay, yeah, this is what the doctor did, this is how he failed to meet the standard of care, and this caused some damage. Now, in some cases, that's one doctor. I can call one doctor, I can spend $2,000 to get him to give us an opinion, and then that opinion will either be, yeah, he violated the standard of care and the guy got hurt, or he didn't. A lot of times, though, you'll have a case where maybe the emergency room doctor failed to diagnose something. And I'll have to find an ER physician to say he failed to meet the standard of care. And then an injury came after that failure to diagnose, but I have to get a different doctor to come in and say, yeah, this failure caused this injury. And so then I'm $4,000 into the case, and we haven't even filed it yet. And I can tell you, we certainly spend well over 5 figures every year just to say no to lawsuits. Because medical malpractice cases, the cheap ones are $50,000 to get to a jury. And, many times there's a cap on those. And so, it becomes really, really difficult to file a medical malpractice claim. It becomes really expensive really fast.
No doubt.
Yeah.
When you mentioned the cap, what were you talking about there?
So medical malpractice claims are for non-economic loss. There's a cap. I don't know the exact figure. It's in the $700,000 range. So if your doctor really messes you up, or God forbid you die because of medical malpractice, that's a $700,000 case at its best. So we know that going in. We know that the defense attorneys and the medical malpractice insurance carriers can be really aggressive in defending those cases because their worst day, isn't necessarily going to be that bad. And so we know going in that there's going to be a fight. We know going in that we're going to have to be able to prove to a jury pool that really does want to trust their doctor that this doctor made a mistake and violated the standard of care. Doctors win 80 to 85% of the time in this jurisdiction. So if my expert says to me at the beginning of the process, yeah, I can say he probably did violate the standard of care, but here's going to be their defense, and that defense is going to resonate with probably about half the people out there, we usually don't take that case. It's just not worth spending $75,000 of our firm's money to chase after something that we're probably not going to get.
Exactly.
Yeah. So we say no to an awful lot of them. So that's a little bit of a primer of, when we take your case, we are going to spend a lot of money on it. We're going to take the depositions that need to be taken. We're going to travel where we need to go. I'm going to be in Baton Rouge next week in Louisiana, taking the corporate representative of a semi-truck company that will videotape that for trial. I mean, that's going to be about a $2,000 expense that we're adding on to that case. But when we take your case, it means we believe in your case, and it means we're going to do what it takes, to get a verdict, kind of the way you did last week. So
absolutely. Yeah. I'm headed to Indianapolis next week for accident reconstructionist deposition. So
is that Mr. Kevin Johnson you got next week?
It is.
Yeah, we're going to try to have Kevin on the show. That's a deep tease. He's going to come on, we hope, some point in the not-too-distant future. We're talking today about the anatomy of a lawsuit, the value of them, both in terms of what we spend on them and in terms of what our clients go through in order to prosecute the claim. They spend time at the doctor. They spend time in deposition, spend time filling out discovery. These are cases when we take them that we believe very deeply in. But we're going to address the elephant in the room. We come back in segment 2. There's one case that everyone mentions. I've yet to do jury selection without it being mentioned every single time, and that case is, Jacob?
The hot coffee McDonald's case.
Coffee is supposed to be hot, I'm told, over and over and over again. Well, people have written movies about what you don't know about the McDonald's hot coffee case, so we'll get into it a little bit in segment number 2. For Jacob Lawrence, I'm Matt Glenn. You've been listening to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. We'll be back in a few moments.
Cook, Barquette, Ponder, and Walls are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And welcome back to part 2 of Tell Me I Have a Case, the show where we're asking you to take a second look at the world of personal injury litigation. Alongside Jacob Lawrence today, I'm Matt Glenn. You can find us on the web at www.cbpw-law.com. You can call the show 573-708-7105. Leave us a question on the voicemail, and we'll either get your question on the air or maybe even have you come on the air with us. But today we're talking about the value of lawsuits, we're talking about the cost of lawsuits, and we're talking about frivolous lawsuits. And the one that everyone talks about, that everyone brings up, is that McDonald's hot coffee case.
Just last week, as we mentioned in the first segment, in a trial, begin jury selection, really start the first question talking about frivolous lawsuits. And the first guy that stood up, this is what he brought up. And we've seen that happen before. It's pretty common.
It's amazing. The case is over 25 years old, and we're still talking about it to this day. Yeah.
So, we've heard about it a lot. People have heard about it a lot, I'm sure. But what happened in the case?
So, I mean, the long and short of it is, the old woman was in the drive-thru. She was in the passenger seat. A lot of people think she was driving. She was not. She ordered a cup of coffee from a McDonald's in the Albuquerque, New Mexico area, and they parked that car in the parking lot, and she lifted the lid to put some creamer in it. She spilled the coffee, and it fell onto her lap and caused actually third-degree burns right around her genitals and her inner thigh. Had to be hospitalized for 8 days. And had to have skin grafts. So a pretty expensive round of treatment for it.
Okay, so she's not driving the vehicle. She's not going down the highway while she's opening the coffee, because that's one thing that I always imagined about that case.
Right.
Okay.
No, she's not. And I wanna be very careful here. Look, I eat at McDonald's. I think almost all of us do. There's a difference between the McDonald's Corporation and the franchise. And in this case, they really went after not the locally owned businesses that we all know and experience. They went after kind of the corporate headquarters that I believe is located up in Chicago.
Okay.
They were the ones that were kind of the target. And this is where it gets a little bit interesting. Everyone says, well, coffee is supposed to be hot. And I agree. I mean, I make coffee in my house. I buy coffee at the store. Typically, when you make coffee in your home, it's about 140 or 150 degrees above, or 140, 150 degrees. At that temperature, if you spill coffee on yourself, and I think probably everyone has spilled coffee on themselves at some point, you've got about 17 seconds to get that off your skin before it can cause a significant third-degree burn. McDonald's, for some reason, had a policy, and this was a corporate policy handed down from Chicago, that their coffee needed to be 180 to 190 degrees. Now, I don't know exactly why they had it. Some people alleged it was because they didn't want people getting so many free refills. But for whatever reason, they wanted coffee at 180 to 190 degrees. At 190 degrees, it only takes 3 seconds for you to experience a third-degree burn, or it can be in as little as 3 seconds. So you spill the coffee on yourself. You've got 3 seconds to get it away from your skin, or you're going to need skin grafts, which is what happened to this woman. So.
Well, and especially if you're in the drive-thru and not, in the restaurant there where you can run to the bathroom. I mean, obviously that's a different situation.
Right, and you're wearing your workout. I believe she had like sweatpants on that were skin tight, workout pants, and But the key fact that the jury heard was that coffee did not meet her reasonable expectations. Right? If you go to hit an accelerator on your car, for example, you have a reasonable expectation that your car will accelerate in a certain way. And let's say you get into a rental car and the accelerator's been adjusted, and all you have to do is tap it, and it's the equivalent of flooring it, right? Well, you're probably going to put yourself through a wall because you're not ready for just a little tap on the gas to shoot you completely across the parking lot. That's kind of what happened here. If the coffee had been 160 degrees, 150 degrees, she would have spilled it on herself, and she would have had the same experience that she's had probably every other time she spilled coffee on herself. And that is, you've got several seconds to get it off of you. She didn't have that kind of time.
Yeah, that's certainly at least my expectation when I go through a drive-thru and pick up a cup of coffee.
Right.
Some steam, you blow it off and take a sip pretty much right away.
Yeah, at 190 degrees, it's not drinkable. You cannot consume it. An expert actually testified in that case that anyone who actually sipped coffee that was 190 degrees would actually cause burns inside of their mouth. And yet somehow this was allowed to be corporate policy at every McDonald's around the country prior to this lawsuit.
Wow. So she suffers these horrible third-degree burns,
right? And
I think you said an 8-day hospital stay.
I believe that was it. Yeah,
wow.
I believe. Yeah.
That wasn't cheap.
No, and this was not a case where she just, ow, my legs ache a little bit. She had skin grafts in an area where most people don't want to have skin grafts. Not that you want them anywhere, but certainly not around your genitals. And that's where she had to have them. I think it was on about 6% of her skin suffered third-degree burns. She had lesser burns to 16% of her skin. You can go online and find photos of it if you want to. Now, they're fairly gruesome. And I don't necessarily recommend you do it, but they are out there. This case has been really well documented, and you can actually find that. So.
All right, so let's move on to the litigation portion of it.
Yep.
How does that come about?
Well, she comes to visit a lawyer like our office. Initially, from what I understand, she had to go to a lawyer or two before one would actually take her case. And the one that did actually went to a McDonald's and measured the temperature of the coffee and thought, this is different. This really shouldn't happen. You shouldn't get a third-degree burn simply from spilling a cup of coffee.
So those lawyers that she first went through this process that we were describing on the front end on the first half of the show.
Exactly.
And they weighed the benefit against the cost, and the process itself weeded out for those lawyers who thought that would not be a successful claim.
That's right. I mean, she had to. I don't know exactly how many experts she had in this case, but I'm imagining she would have had somebody to testify as to, how hot coffee should be, how hot it typically is if you buy it at Starbucks, if you make it at home, or if you got it at this McDonald's, and then what liquid at that temperature does to the body when it comes into contact. You need experts to teach you all of that. And then, so that would have been tens of thousands of dollars just to get that part of the case ready. And then you have to depose her doctors to talk about the treatment she got, the recovery that she made, the scars that are most likely permanent. So those lawyers in New Mexico spent a lot of money to get this woman's story told to a jury in Albuquerque.
Yeah, wow. So what about McDonald's side of this? What did they know about their coffee? Did they... before this incident happened?
Well, by policy, they had they knew it was between 180 and 190 degrees. They had reports of burns in the past. They were not, in deposition, said they weren't really surprised by that. They kind of knew it was going to happen. It was kind of part of the cost of doing business for them. So, I mean, they didn't, they responded the way most people respond to this lawsuit. They hear, yeah, it's hot coffee. It's supposed to be hot. You assume that risk. And because you assume that risk, it's not our fault that you got hurt. So that was our attitude.
And did it go to trial eventually?
It did. It did eventually go to trial. She offered to settle early on just for the cost of her medical bills. They refused to pay those. It's worth noting that as she was treating for these burns, during the time in the hospital, she lost 20 pounds. Yeah. And that was close to 20% of her body weight. She dropped from about 103 pounds down to 83 pounds.
Oh, my gosh.
This was a significant setback to her. But, yeah, they fought all the way to trial. They got a jury verdict. It was a few $100,000 in compensatory damages, and then she was also awarded punitive damages. Now, punitive damages, Jacob, are different than compensatory damages. You're closer to the bar exam than I am. Tell the folks about punitive damages.
Okay, so first, compensatory damages are the main category that we see. It's to make up for the loss. Right. So those things include medical bills, lost wages, those types of things. That's what we're talking about when we say compensatory damages.
Right.
Punitive damages are more to punish the defendant and to deter that conduct from going forward in the future.
Right.
Does that make sense?
Yeah. No, absolutely. And that's why the defendant, their identity and their wealth matters a great deal when you're talking about punitive damages. The analogy that we'll use at trial is, if you make $60,000 a year and you get a DUI, the fine for that DUI might be $5,000. Well, if you make $60,000 and you get fined $5,000, that's a significant fine. That you're going to feel that. Yeah. Now, if you make $600 million a year and you get a $5,000 fine, that's not a deterrent. That's not going to bother you. So the question in any punitive damages claim is, how do you get the attention of the defendant? How do you punish them in such a way that makes sense to the case and it is appropriate.
Yes. And fixes it and makes it safer for the future.
That's exactly right. And so there are a lot of policy debates in our country today about whether an individual plaintiff should receive the entire punitive claim. In Missouri, for example, if you achieve a punitive damages claim, half of the money you might collect goes to the state of Missouri, and they spend it a certain way. Right now, they've got a fair amount of money because they just collected I think it was $2 billion worth of punitive damages out of a Johnson & Johnson trial in St. Louis. Mark Lanier, whose seminar we went to, he collected that, and so now Legal Aid, they've got some money.
Yeah.
They've got some cash to deal with.
Yeah, so when you hear about these punitive damage lawsuits, all that money is not necessarily going straight to the victim.
No, it's not. And, punitive damages have to be proven typically by clear and convincing evidence rather than just more likely than not. It's a higher standard. It's not quite beyond a reasonable doubt, but it's clear and convincing. And so, when you see a punitive damages award, understand that 12 citizens heard all the evidence, sat there in trial and made a determination that, that company, in this case McDonald's, they knew their coffee was too hot. They did it anyway. And it's the old saying that they were putting profits ahead of people. And if you do that, you open yourself up to punitive damages. In this case, to calculate the punitive damages, it was kind of nifty. They decided to punish McDonald's 2 days worth of coffee sales. 2 days worth of coffee sale revenue. And you know how much that was?
I don't.
$2.7 million. Wow. That is 2 days worth of coffee sales for McDonald's. Now, I'm guessing a corporation like McDonald's, Ronald probably has that in that overgrown shoe of his and probably would be able to pay cash. That amount got reduced by the judge. It got reduced again on appeal, and eventually there was a settlement that was confidential. We don't know how much it was. It was far less than the $2.5 to $3 million verdict that she achieved. But if you start to look at the background of that case and kind of peel back the layers, it wasn't just that a cup of coffee was too hot, right? Or it was hot and it burned her. She expected hot. What she didn't expect is 190 degrees. And what she didn't have time to react to was the fact that it caused those kind of burns inside of 3 seconds. That put her in an impossible situation. And when she spilled that on her lap, it was a significant disruption to her life.
Yeah. And apparently that jury agreed that was the reasonable expectation and thought it was important enough that they needed to deter that conduct going forward.
That's right. And they, a jury is at the end of every single case. We say it all the time to our clients. At the end of the day, we're going to tell 12 strangers that none of us know and none of us will ever see again your story. And we're going to then ask them to pay you for everything that's been taken from you. We don't take that case. We don't put our time into it, our money into it, and frankly our clients' time into it if we don't believe that we can convince most reasonable people that something was taken from them and that they deserve to have it paid back.
Yeah, and just generally that reasonable expectations that we're talking about, I mean, that's very common throughout the law, isn't it? I mean,
sure.
That's kind of one of the guiding principles of the way the law works, whether the defendant knows that they can cause danger in that situation and whether the plaintiff would expect that danger.
Right. We see it all the time in products liability. If you buy a product at the store, you have a reasonable expectation that you could use it in a certain way and then, that it won't cause harm to you. That's what you expect, and that's frankly what you deserve. If we talked about it briefly, the Ford Pinto case, when Ford knew that their car was designed in such a way that a rear-end collision was going to cause the car to explode, they chose not to change that design. When you see behavior like that, that's when it's ripe for a jury to get involved and hold that company accountable. So
absolutely.
So you've been listening to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Jacob Lawrence, I'm Matt Glenn. Thanks for joining us. We'll see you next week.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.